When we're first contacted, almost inevitably it's by a telephone call. In that initial telephone call, we're prepared to, of course, discuss matters with the client and deal with any issues they might have. A telephone call can only achieve so much, so I invite the client to come in to see me and have, as it were, and I do say this to clients, have a fireside chat, which may sound a little bit cheesy, but what I want to do is to have the client relax as much as possible about coming in. We never lose sight of the fact that when a new client comes to see us, and indeed throughout the process, it's a very, very stressful experience for them. And what I and my colleagues try to do is to ensure that the client feels as comfortable as possible. It is important that we establish exactly what it is the client is looking for, what the client's aspirations are, and indeed ultimately to get out to the clients that they are in charge of the process. We never assume what it is the client wishes to achieve. We like our clients to tell us what their aspirations are. We encourage a conciliatory approach. In my experience, matters of this nature are always best dealt with by achieving the largest measure of agreement possible. Inevitably, there are those cases where that isn't possible, and we're well equipped to deal with those cases as well. Where difficult matters like this are dealt with in an atmosphere of hostility, that ratchets up the stress, and I have to say also it ratchets up the legal fees. When a client consults us with matrimonial difficulties, one of the things I try to avoid is using the D word, divorce. If that's to be on the agenda, then of course it has to be on the agenda. But where a client says to me, I want a divorce, I do like to explore the question, do we really have to do this? Because in life people can, on occasions, knee-jerk react, and I do like to explore the prospect of reconciliation, never putting a client under pressure. I always want it to be the client's decision as to whether or not they do want a divorce, but very often, not very often, but sometimes one finds that a client will want to think and think again. I think it's really important that family lawyers do not adopt a formulaic approach. Client comes in, they may say they want a divorce. I would rather have an instinctive approach to that and explore with the client whether it is really what they want to do. And if they do, of course, then they will have our wholehearted support. But I do like to establish whether or not the marriage has truly broken down, or whether it's an interlude in the marriage which can perhaps be addressed in other ways, possibly by counselling. And we do have referral resources with respect to counsellors and, of course, mediators, because sometimes when people approach us, divorce is the last thing they want, even though there are issues which do need to be considered, such as arrangements for the children and what the position should be like in terms of financial and property matters. The divorce sometimes is further down the course. Clients wish to resolve other issues, and we're happy to advise and assist in relation to that. Agreement inevitably is not always possible, and if that is the situation, matters do have to go to court. Before cases in relation to financial disputes and child-related issues, before those matters can go before the court, a referral has to be made to mediation. We have connections with local mediators, and we would refer clients to mediators. That does not necessarily mean that magically an agreement is going to be reached. But before you can issue a court-based application, clients must have information and be assessed about mediation. That situation having been achieved, an application is made to the court, let's say in relation to financial and property matters. When that happens, an application is issued for what's called financial remedies. Once you send in your application to the court, the rules require the court to issue within a few days a notice of first appointment. That notice of first appointment timetables what is to happen in the case so that it doesn't drift on aimlessly forever and a day. The timetable initially obliges the parties to make full and frank disclosure of their financial circumstances and other relevant circumstances. There is a preliminary hearing at court, which is called a directions appointment, which is a kind of judicial housekeeping. The judicial housekeeping will deal with what happens in the event that there are disputes as to valuation of property or other assets. One of the main directions which a court will give at that preliminary hearing is to move the case on to what's called a financial dispute resolution hearing. That is an in-court mediation conducted by a judge, and the lawyers, and by the way, at this point in a case, it may be that the services of a barrister is taken on board. At this point, there's heavy concentration on trying to achieve a settlement, because in theory, at the point of the in-court mediation financial dispute resolution hearing, the court has before it, and the parties and their advisors have before them, all the required financial information. If matters, sadly, are not resolved at that stage, then there is a third court hearing, which is a final hearing, where the judge hears the respective arguments, listens to the evidence and submissions, and will make a decision.